Hi, I'm Nikki Jovicic, owner of LookUpStrata and also Managing Director of Tower Body Corporate, a body corporate management company on the Gold Coast. For this Queensland webinar, we're welcoming back Michael Kleinschmidt from Stratum Legal and Chris Irons from Strata. Today's webinar is about strata and short-term letting in Queensland. Michael and Chris will be presenting us with the facts and what your options are, both from the point of view of the owner with the short let apartment and the residents living with short-term letting in their building. Today's presentation may provide you with a different view of short-term letting. We'll be looking at the range of regulatory approaches that have been undertaken in different places, what the Act says, and what adjudicators have said. After the presentation, we'll cover some questions. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. I'm delighted to introduce our panelists today, Michael Kleinschmidt from Stratum Legal and Chris Irons from Strata. Michael is a legal practitioner director of Stratum Legal, a specialist strata law firm on the Sunshine Coast. Michael practices in all areas of strata law for every type of stakeholder across Queensland. Michael is a fellow and council member of the Australian College of Strata Lawyers. With an unmatched perspective on the strata sector, Chris Irons is a thought leader for strata issues and dispute resolution. For over 5 years, Chris was Queensland's Commissioner for Body Corporate and Community Management, the only role of this type in the world. After working for well-known strata law firm Hines Legal, Chris is now an independent strata consultant, working under the banner of Strata and helping clients to untangle their strata issues with tailored solutions. Chris brings to the table over 2 decades of leadership and public policy development and is a nationally accredited mediator. He is a frequent media and content contributor on strata issues. In his capacity as independent consultant, Chris is Senior Vice President of the Board of Strata Community Association Queensland. Chris is also the President of Northside Connect, a non-for-profit community and legal services provider based on Brisbane's North Side. Both Michael and Chris are regular contributors to LookUpStrata. They assist many of our Queensland readers by responding to Q&As, and they both regularly appear in our bi-weekly newsletters and monthly Queensland Strata magazines. If you've been following LookUpStrata's webinar journey, you'll know both Michael and Chris are regular presenters. This is the 3rd time Michael has joined us for a webinar. We covered solar in strata and Queensland renovations in recent presentations, and Chris has joined me on multiple occasions to talk about parking, smoking, self-managed strata, and the list goes on. Welcome, Chris and Michael, to today's webinar. I'll leave you to do the presentation.
Thanks, Nikki. Michael, everyone, hello. I always get a bit nervous at this point when I hit the share screen button, so bear with me.
Just make sure it's nothing embarrassing, Chris.
I've already taken precautions in that regard. I think we have it. Please say yes.
Yes.
Hold on.
Even better. Well, welcome everyone. Let's get right into it. Michael and I have this presentation, which will go for a little while. We want to allow enough time for Q&A as well, but we do want to cover a bit of content to clarify. This graphic that you're seeing on screen comes from, I believe, Barcelona several years ago, when that part of the world was having some real issues around tourism and short-term letting in particular. And as you can see there, the protester had some pretty choice words to say about Airbnb in that case. And we put that graphic up, I guess, to illustrate that it's a strongly contested issue in strata, short-term letting. We're going to try and work our way through the facts, as Nikki indicated at the start, but also Michael and I are going to give you perspectives which we think will assist to move forward. So, what are we actually going to cover? Overview, of course. Michael and I very much experts in strata in Queensland, and we're happy enough to say that. I think you're happy enough to say that, Michael, aren't you? Yes. That's the perspective from which we'll be talking today, everybody, but some of what we say will have national application. A bit of where to next in this space, our tips and Q&A. Michael, when we talk about short-term letting, we are not just talking about Airbnb, are we?
Yes, unfortunately, Airbnb has become the Xerox of the short-term letting space. Airbnb is just a platform. Before Airbnb, there were funny things like adverts in the paper where people would rent out their properties directly. So all Airbnb is a platform to put micro suppliers in contact with individual consumers.
Absolutely. We always like to, or I always like to, I'm pretty sure Michael does too, likes to define the terms of what it is that we're actually talking about. It's a funny one, isn't it, Michael, in the sense that when we talk about short-term letting, we don't have definitions for short-term letting per se under strata legislation. We have a kind of a, do have a guide though, don't we, when it comes to people who are on leases. So in Queensland, if you're on a lease of 6 months or more, you're kind of almost considered a resident, aren't you, Michael?
Yeah, and this is different strokes for different folks. Residential or residential commercial activities are regulated in a variety of different ways. Obviously, there's the planning law, so there's some definitions there. Then you get things like the building construction law and safety standards, differences between class 2 and class 3 buildings. So there's a definition there. The 6-month one is really finds its way into our discussion by virtue of the residential tenancies legislation. And that's not bad, but we always need to remember that when we're interpreting one act, like the Body Corporate and Community Management Act, you look to that act first. You don't go looking in another act. But when you're looking for a rule of thumb, you know, what's the difference between short-term and longer-term residential accommodation? You know, there are various definitions, 3 months, 6 months, but 6 months isn't bad.
Yeah. I guess what we're talking about here to some extent is about the use of your home or your lot, in this case, in a community title scheme, and the concept that it's yours to use as you see fit, but subject to, well, in some cases, as you'll see today, some pretty intensive qualifiers on the use of your home. And I guess also, Michael, we're coming at this at a time when there's been a lot of changes in the world, and a lot of those changes have found their way to short-term letting in strata.
Yeah, I was up in Port Douglas a couple of weeks ago, and they've got some very interesting problems there at the moment. They've got both ends of the spectrum because they're a reasonably small housing market. On the one hand, they've got people who are moving into traditional short-term accommodation to live there on a longer-term basis. So some of their tourism stock, and they're a tourism town, is turning from tourism stock into long-term stock. And then they've got other stock, which has traditionally been long-term, which has been purchased by people, from Sydney or Melbourne who are looking for a bolt hole or to participate in the Great Resignation. So they've got, they're copping it on both ends of the spectrum. And when you compare the size of the housing markets in those places, it only takes just a few people from Sydney or Melbourne, comparatively speaking, to soak up a lot of the available stock in a market like Port Douglas.
And for our listeners, viewers who are not really familiar with Port Douglas, a wonderful place in North Queensland, but not a big place, not a big place. And Michael's right, that does have some significant impacts. So, strata and short-term letting then, and we, I guess we're using the terms strata and body corporate and owners corporation relatively interchangeably for this presentation. In Queensland, the term is body corporate. We do know that strata is probably a very common term elsewhere. I guess the thing to remember here is that different jurisdictions right around the world, so not just Queensland, but right around the world, are taking some very different approaches to short-term letting. Michael was in Port Douglas recently. I was at the other end of the country down in Tasmania not that long ago. And I know that Tasmania has some incredibly intensive rules about short-term letting there as well. So there are different ways to approach the problem. As you'll see a bit later on, the key is defining the problem, which then in turn defines the approach that you take. Michael, that's a grab bag of issues with Strata short-term letting.
And the funny thing is, on reflection of this one overnight, as many of those issues occur with long-term or permanent occupation of units as they do for short-term. It's really a description of antisocial behaviour, and antisocial behaviour can arise from short-term letting, long-term letting, or owner-occupiers. So it's a mistake from the get-go to think that short-term letting is inherently more difficult or more problematic than any other sort of letting. And in fact, adjudicators in Queensland have consistently rejected that notion.
Yeah,
so.
Absolutely. We see there those antisocial issues that Michael was just referring to. Nuisance, there is such a thing as nuisance under Queensland body corporate legislation. But then there are the ones that come up quite frequently when people voice concerns about short-term letting, issues of security, parking, of course, the use of common property. Insurance is an interesting one. I've certainly heard of instances where some bodies corporate are finding it difficult, if not impossible, to renew their policy if a lot or lots in the scheme are being used for short-term letting. And then, of course, there's bylaw enforcement. Bylaw enforcement is an incredibly convoluted process in Queensland, and it's a very long process as well. I guess, Michael, all of those issues are based around the idea that people who are the short-term tenants, and the phrase used in Queensland is occupier, not tenant, but those people who are short-term occupants, it's generally thought that they don't have the same kind of investment or engagement as either longer-term occupiers or owners.
Yeah, and look, again, lawyers are professional pessimists because we always see the problems and try and implement the solutions.
Not just lawyers.
And so, and no doubt the dispute resolution service that you had the fun of running for 5 years, Chris. So when you see the problems, and human beings always try and draw out patterns and understand why. It's one of the things that makes us what we are. And if we see that sort of behaviour and it correlates with short-term stay, well, then we say, maybe it's short-term stay that's causing this. Over the years, I've developed a slightly different outlook, and I put it down to it's the person who's causing it. It's not necessarily the activity or where they've come from that's causing the issue. It's the person. And so addressing the person and sheeting home responsibility to the person is most of the time the solution.
Yep. Well said, Michael. I think that's a really important point that everyone could probably take away from this. So what is the Queensland perspective then? So effectively where it comes down to in Queensland, and we think this is a good illustration for people in other jurisdictions too. Under Queensland's Body Corporate and Community Management Act, it's Section 180, subsection 3 of that legislation, which is in relation to bylaws. And here is the provision replicated in full. If a lot may lawfully be used for residential purposes, the bylaws cannot restrict the type of residential use. So Michael and I are very used to dealing with legislation that is ambiguous. Body corporate legislation is pretty ambiguous in a lot of cases. This is one instance where it's a little more definitive, and whether or not that's adjudicators have taken it into account, adjudicators in Queensland have consistently applied this provision to mean that a bylaw cannot prohibit short-term letting. So just for clarification, in Queensland, we have the Commissioner's Office, which I used to run. That Commissioner's Office is the exclusive jurisdiction for body corporate disputes in Queensland, with a few minor exceptions, or a few exceptions. And adjudicators in that office make legally binding orders. And Michael, that's been tried and tested over a few cases now, hasn't it?
Yes, one of the fun parts of my job is to try and find ways around those sort of provisions, because I've argued it from both sides of the fence. And the distinction there, of course, comes down to what does residential use mean. It's a key feature of our 1997 Act that what it actually also does is effectively recognise and facilitate the role that tourism accommodation plays in Queensland. It's been a bit of a pioneer. It's one of those pioneering things that goes out into regional areas, and by providing the ability for individual owners to invest in a property, that generates the capital required to get a accommodation building going. And so you've ended up with places like the Gold Coast have basically been built off the back of individual investor investment activity in strata schemes to provide tourism accommodation. So it's part of the DNA of the Act that short-term lets are a residential purpose. Two other provisions to have a look at if you're interested too. Subsection 4 goes to restricting dealings with lots, including restricting letting or leasing. And some of the bylaws have been held to be contrary to that. And the other one is, I think, sub 7, where it talks about a bylaw being oppressive and unreasonable. In Queensland, not that long ago, we had an interesting adjudicator's decision, which basically said that smoke drift is an inherent, nuisance by its nature. And an argument has previously been run that short-term letting is the same sort of thing. And of course, if you then have a bylaw in place that bans it, what you're trying to do is to ensure that you are banning something that's inherently a nuisance. That argument has failed as well. So yep. Direct bans as opposed to regulation are really going to have a problem.
And in a lot of those cases that Michael's sort of referring to, they're the buildings, the committees, because they're the ones making the argument effectively. It's usually the committee trying to prevent an owner from short-term letting, make an argument about amenity, the amenity of the building, and usually about the location of the building relative to other locales or the amenity of the surrounding area. And it's never gotten up, that argument, and consistently, and it's also never gotten up on appeal either. We did have one case relatively recently, there's the link for it there if you want to go and read it at your leisure, where a bylaw prohibiting short-term letting was effectively upheld, but, and this is a big but, this is a very, very different scenario, isn't it, Michael?
It is. This particular ruling, it's unfortunately a whole heap of sound and fury signifying nothing. The reason being that it relates to schemes that are still regulated under the old Building Units and Group Titles Act from 1980. It's an interesting decision too, in that while it's the correct decision, the magistrate who made the initial decision quite a good lawyer and magistrate. I used to brief him when he was a barrister. And then the district court judge on appeal, also very good. It's a correct decision of law, no doubt about it. But the law that's being relied upon principally is a House of Lords decision relating to a decision or a dispute coming out of the Turks and Caicos Islands. And the reason that that was able to be taken into account is that there's no direct analogue of that section 180 subsection 3 in the old Building Units and Group Titles legislation. So because of that, some different law about what a residential as opposed to a commercial use was regarded as could be taken into account.
Yeah. So yeah, just to sort of pick up on that point, that particular judgment that we've referred to in the first stop point, it's a very small number of schemes, buildings in Queensland. They just so happen to be quite prominent buildings in some cases, but it's still only a very small number. So what's happening in Queensland at the moment is that our Deputy Premier, and it's a weird kind of division of responsibilities in Queensland, the Deputy Premier also has housing portfolio responsibilities, and these issues are falling under the housing umbrella, whereas the Attorney General in Queensland is responsible for strata issues. So the government has announced a review into short-term letting, and that was done quite mysteriously and randomly very recently. Nobody knows what it is. Nobody knows what the terms are. Nobody knows how it's going to proceed. Nobody knows who's going to be involved. But it's definitely on the agenda. The strata legislation reform process that's currently underway in Queensland, of which Michael and I are fairly active participants, is also looking at the short-term letting issue in strata as well. It's falling under, Michael, that broad umbrella of amenity, isn't it?
Yeah, so, there's been 2 discussion papers. We can't talk in too detailed a way because the the workings of that particular group are subject to some restrictions, but there's been discussion about amenity and there's been discussion about management rights. Obviously, management rights isn't 100% short-term let. There's other activities that go on with management rights as well. But yes, amenity, it's popping onto the radar because of amenity, which comes back to that sort of anti-social aspect to some of the people who stay.
Absolutely. Let's plow on. So that kind of leads us into the next point, where to from here. And I guess this is what we were talking about at the start, about defining your terms and being sure. Is the issue here, and Michael, you and I talked about this quite a bit, are you concerned about unsocial, antisocial behaviour, or is the issue something else? Is it actually about housing stock?
Yeah, and this is the key, because when people talk to me about short-term letting, they typically come in with sort of three agendas. The first one is they want to deal with antisocial behaviour. And the difficulty there is that our bylaw enforcement process under the BCCM Act in Queensland is really pretty involved and pretty problematic and expensive. It should be a lot easier than that. From a housing stock point of view, there's lots of solutions out there that have been mooted. If you draw out the experiences from the other jurisdictions, it's usually capping, taxing, or regulating. And you end up with those sort of three things. So they're the first two things that people come to me with. And the third one is that, you know, and this is unfortunately, you see a few people with this agenda, is they don't like management rights in their scheme. And so they latch on to the issue of the day, and the issue of the day is short-term letting because of these COVID effects that we're all suffering from with the housing stock problem. So they'll jump on that bandwagon. But if you look at the real issues and you say antisocial behaviour and housing stock, if they're the problems, one or the other, they've got different solutions.
Really good, really important point, I think, that one, Michael, because if you are not clear on the ill that you are attempting to cure, then you will find your ability to cure it is next to none, basically. Then what's the role of government intervention? We spoke just a moment ago about review into short-term letting. Is there a role for government in direct regulation? Is there a role for government to allow the prohibition of short-term letting in strata? And Michael, then there's the impact of some of your favourite abbreviations there.
Yes, many moons ago, I used to do a little bit of planning and environment litigation. I picked up a town planning degree and had some fun with some town planning appeals. And I came across some acronyms that have stayed with me ever since. Cave dwellers are citizens against virtually everything. NIMBYs are not in my backyard. And SOBIs, of course, somebody else's backyard. So that tells you where their perspectives are. There's an important point to be made out of that, though. And look, at an individual level, we're all pretty good at looking after our own interests. And it takes more and more people, unfortunately, to get to the point where we'll look after our collective interests. That's why regulation of use, for example, is, I think, in my view, pretty much best done at a local government level, because a local government can take into account the needs of the community and make planning decisions around use and what uses should be allowed in various areas. It's close enough to the people to be responsive, but it's far enough away from the people that, you know, self-interest isn't going to rule the day every day of the week.
Yeah. I think absolutely, Michael. I won't get much disagreement with me. From the strata perspective, then, what is the role of any potential strata reforms here to impact upon this? So we spoke about this just a moment ago. In Queensland, it is virtually impossible to have a bylaw which prohibits anything be held up as valid. There are some very rare exceptions, but and this doesn't just apply to short-term letting either. This applies to things like smoking as well. But that's on the table at the moment, potentially. What about fines? Look, I personally am a big fan of the idea of fines in a strata scheme. I know that there are many people who are violently opposed to that idea, but could fines be a suitable disincentive to some of the antisocial issues that we've been talking about? I have found over so many years that hip pocket impacts are the best possible way of changing behaviour in strata. And then there's the vexed issue of the actual enforcement of strata bylaws. We said before about how challenging it is. It's impossible to enforce a bylaw against an occupier in Queensland, or short-term occupier anyway, because of the process which is involved in it. And then, Michael, there's also the vicarious liability issue as well, isn't there?
Yeah, and so the vicarious liability dimension, because of that difficulty in enforcing a bylaw against an occupier, at least a short-term occupier, you know, the reaction to that is, well, let's make the landlord responsible. And so there's a whole heap of landmines associated with vicarious liability. You know, there are responses to this that can start the process. I know just watching the chat that somebody's already popped up and said, look, you know, you have a problem with short-term stay in that a lot of the guests aren't actually aware of the bylaws and they can breach them unintentionally. You know, I wear a number of different hats. I'm a legal panel member for ARAMA, and I'm also on the ethics committee for SCA Queensland. So, you know, I like to think that I sit in the middle. But one of the things that I'm aware of is that under the standard conditions of stay that ARAMA provides for their members, you know, the guests are being provided with a copy of the bylaws so that they're aware of what those rules are. And of course, you know, the resident manager can toss them out if they breach the bylaws.
Yep. It's again an excellent point, Michael. And going back to our very first point about we're not talking about it's not just Airbnb, it's not stays, it is short-term letting, which takes in a whole range of issues. So we've raised a lot of points and some problems, but how about we have a go at some possible practical solutions here? We've said this numerous times, and so therefore we're going to say it again. Define your problem. What are you actually trying to address here? Chances are, Michael, if your issue is an ideological or philosophical objection, that is your wrong place to start here.
Yes, if that's the issue, go and put a petition to Parliament.
Absolutely.
Talk to your local member. Join a philosophical society. Join a political party. And I don't mean to be flip for those people that are really suffering. I mean, there are practical things that you can do. But, you know, the interesting thing I think about Strata too is that these are intended to be communities and there's always give and take. And I know, Chris, I don't know whether or not this is your anecdote, but I've certainly heard it before, you know, the story of the shift worker who pulls his hair out because a kid upstairs is practicing saxophone at 3:30 in the afternoon when they're having their sleep after their early morning shift. You know, one conversation between those two lot owners solves that problem by rescheduling the saxophone practice.
Absolutely.
You know?
Yeah, so many of the strata issues that I have seen over the years could potentially have been addressed by that kind of informal approach. You don't have to go and take the hammer to the nut straight away, in other words. Next up, and this is a pretty straightforward one. Get your bylaws fit for purpose. Bylaws are the tool by which bodies corporate can really regulate and get the results that they want in their scheme. But there's no point doing that if the bylaws, first of all, are not fit for purpose, and secondly, they're not valid anyway, or they're not going to be valid anyway. That's a job that Michael does frequently, I'm sure. If your bylaws are more than a few years old and they haven't been looked at in more than a few years, chances are you've got several invalid bylaws there. And that's about putting good systems in place. And I think largely, I thought about this after you and I did our rehearsal. Yes, we did rehearse, everyone. Michael, I thought about this afterwards, and this is really where communication becomes key in the issue. And I've seen a few questions pop up in the chat already about this issue, about how do we ensure that occupiers know what is expected of them? How do we ensure that they know what the bylaws are? My term for an anecdote, Michael. So I am an occupier in a community title scheme, a long-term one, that is. When I first signed my lease here, there's a box in the standard lease in Queensland which says tenant has seen copy of bylaws, and it was ticked, which is fine, except I've never seen the bylaws for the scheme. And I brought it up and I said, oh, can I have a copy of the bylaws, please? And they said, no, they're just the standard ones about parking and pets and parties. You'll be fine. They knew what I did for a living at that point, Michael, and they still said, you'll be fine. So I guess the point that don't assume that people know things. You've got to make sure that people are aware. And then there's ways and means of how you do that. So a big sign in 40-point bold typeface, which says, you will not do this, you will not do that, as opposed to a sign which is more framed in a much more gentle, warm fashion. I can tell you right now which one of those two signs will get you the better chance of getting compliance. Hint, it's not the first one. Michael, did you want to add anything on that one?
Look, some of the best body corporate managers I know, once they're aware that there's been a change of ownership, for example, the BCCM Form 8 notice of change comes in, and they'll send out a pack, literally send out a pack. I'm your body corporate manager. These are the people on the committee you can talk to. Here's a copy of the bylaws. Your next levy notice is likely to issue around about this date. And just that initial sort of, not crowding people with info, but giving them just some really pithy stuff to start the conversation. And, bylaws that are framed in terms of motherhood statements or aspirational, statements don't get you anywhere. Having prosecuted someone for having a dog in a community title scheme successfully, and getting a fine of $300 when the prosecution costs were in the thousands, I can tell you that the best bylaws, as the start of that process, are simple. They're easy to prove a breach of, and then when you're looking at your systems, if you've done the stuff that Chris is talking about initially, with making people aware, and then you move into what I call implacability, right? You've clearly communicated, so there's a clear expectation. You then turn around and say, right, well, there's a breach. Here's your notice of breach. It's clear, it's concise. That's the formal stuff. The informal stuff can be a quick telephone conversation with a committee member that says, hey, look, is there a reason for this? Is there a reason that you're parking in the visitor's car parking space? Oh, look, my son, my son's been sick. My sister's come up to help look after, get the story behind it, and then do what you need to do. In terms of
I can't emphasize that enough, Michael. It might be the situation that one weekend some short-term guest drops some bottles off their balcony of a high-rise, and that's an obvious problem. But you can't assume that the owner of that lot knew or knows about that. But if you brought it to their attention as a committee, hey, just to let you know, not sure if you knew, but this happened on the weekend just past. It's a real concern. You might be surprised at the speed with which things are addressed in that kind of situation. We've got quite a few questions there, so we might try and wrap this up. This goes to what you were just saying, Michael. Ensure that there's some good evidence gathering. So if you're going to be enforcing a bylaw, if you're going to be pursuing nuisance breaches, well and good. There's no point in doing that if you can't objectively demonstrate what it is that you're trying to prove. That's, Michael, that's photos, it's logbooks, it's recordings in some cases.
Yes, if there's the old picture's worth 1,000 words, then a video's worth 1,000 pictures. And good objective stuff like that is good. CCTV, those sorts of things, you've got to be very careful when you're making that decision as a body corporate as to whether or not that's what you're going to do. But there are other forms of objective evidence as well too, and the standards are pretty high. I wrote an article not that long ago about the price of not letting go, where there was some very, very good circumstantial evidence of some bylaw breaches, but the adjudicator didn't agree. So the standard is pretty high, which is why it's really good to get your evidence lined up. You know, an eyewitness is nice, but an eyewitness with a photo or a video is much better.
And with dates and times as well. There's no point, again, don't go into an ideological discussion about it. It's a factual issue. And then finally, if you do have a problem, if there is a problem, you have to be prepared to follow it through. So this is the putting your money where your mouth is tip. So you've got a problem, you've got some issues with short-term letting, well and good. There are ways and means to address it, but the fact remains, if you are not prepared to follow it through, then nothing will change and you won't get any outcomes that you seek. And there, Michael, enforce, prosecute, and keep doing it, right?
Correct.
That brings us to the end of our presentation proper. Over to questions. Nikki, I might stop sharing screen at that point so we can bring ourselves back.
Excellent, thank you. That's wonderful. Before we jump in, we did have some questions that were submitted, which are really, really great questions, and we'll jump to those in a minute. But I just wanted to mention, when you were talking then, Chris, about the glasses or the bottles being dropped off from the balcony, we had a question come in from Chinton saying that this is a similar situation, but the unit is used as an Airbnb, continuing flagrant violation of the body corporate bylaws with respect to visitors' car parking. So property owner advertised on Airbnb implied that there was free parking available. So she's just said thoughts. So what do you do when, number one, I mean, obviously you've mentioned like make sure that there's a copy of the bylaws there and informing everyone that's coming through. But if the actual owner of the unit is misrepresenting the unit with their advertising, what can you do about that?
I'll have a go at this first and I'll hand over to you, Michael. So for me, it starts with approaching that lot owner and having some choice words with them about that, because at the end of the day, their misrepresentation actually has an impact upon them as well as everybody else in the building, because it's an impact upon their amenity, which is in turn an impact upon their property value. So it's got to be it's all about communication, the right words framed the right way, communicated at the right time, and with the right motivation to that owner in the first instance. There may be some options to go to Airbnb and raise a concern about the listing. So Airbnb does do some self-regulation. I'm not sure how much, but they do some. I'll stop there. Michael, over to you.
Yeah, look, this is some fun problem solving. I'm going to be careful because I'll give away all my secrets. But there's some fun ways to approach this. I mean, I usually start by having a look at the planning approval or the development approval and see what it says about visitor car parking. Then I'll have a look at, you know, the issue of what's actually going on. There's a bit of a furphy out there that short-term tenants, short-term occupiers are not occupiers for the BCCM Act. And if you actually examine all of those cases to do with, you know, what a residential use is. So on the one hand, if short-term stay is residential use, then someone who's staying short-term is a resident and therefore an occupier, and therefore they're governed by the bylaws, right? So if you put that together with, for example, a bylaw similar to what was in the Petrie Mansions adjudication from years ago, where you start imposing some conditions on people who offer short-term stay to do with, you know, providing a copy of the lease or the terms of stay with the body corporate, etc., so that the body corporate can find out who that person is. You start to get into a position where you can actually enforce the bylaws. And the other one I'd say is that depending on the terms of the development approval, you can actually have a look at enforcing the terms of the development approval as well. So there's a number of different ways to attack it. It really comes down to how bad the problem is and how you know, what sort of commitment you've got to solving the problem. Chris's solution is cheap, mine's expensive.
Depends how much I'm engaged, Michael, then it might not be so cheap.
And then just off the end of that too, Annabelle's just asked, what about if the host is putting up pool area rental for the day? Can they rent out common property?
Geez. They can under some incredibly difficult circumstances, Michael.
Yeah, we actually gave some advice about this. There was there was a local personal trainer offering aqua aerobics classes in the scheme pool. That particular one, because of the jurisdiction that it was happening in, there was some public pool registration requirements, and the committee was able to sheet that home to the operator. And you notice Chris has already talked about sort of hip pocket motivation. You know, that one exploded that whole business model because the costs could be legitimately passed on. And so that's a good technique. You know, when people talk about disruption, so whether it's Airbnb or Uber or whatever, you know, they're talking about disruptive business models. Whenever you look at those quite closely, I mean, you might call me an old cynic, but to me, it's just removing the middleman and creating or operating in an unregulated way. And so once you give proper attention to those things and you start putting the regulation back on top of it to make it work and make it work properly and lawfully, those compliance costs go up again, and then the model becomes less attractive.
That's right. And so just back to the question, Nikki, common property can only be leased or used exclusively under some very tightly controlled circumstances. In a number of cases, it'll require a resolution without dissent. So good luck obtaining that in that particular scenario.
Okay, thank you. Okay, we had another one that Peter had asked in chat as well to say, my question is, how long can a short-term let be before it becomes part of a tenancy under the TRA 2008 Act?
Section 31, subsection 2, 6 weeks or longer holiday purposes. So if you're longer than 6 weeks for holiday purposes, you are no longer exempt.
Okay, great. Thank you. All right, we had a question that was submitted to us via email from Stephen, and this one was, our DA is for multi-unit residential, so uses for full-time residents or owners, weekenders, definitely not short-term letting. We also have a bylaw stating houses are for residential purposes only. Regardless, some lot owners continue to short-term let. Council advised lot owners at the end of last year, but they are unwilling to prosecute owners under breach of DA. Our committee is doing nothing to stop this. They're not enforcing the bylaws. I bought my lot with the understanding that it was a residential community title. I have some mental health issues which are exacerbated by unknown people wandering around the development and using the facilities. Is my only option to sell up and move away?
Stephen, I'll kick this one off and hand over to you, Michael. Stephen, I'm sympathetic to what you're saying there. I can understand your point about unknown people, so that's fair enough. For me, you've hit the nail on the head with your point. Council are unwilling to prosecute offenders. That's their job. Council are the ones who are doing the regulation in this space. So if you have a problem that a local council should reasonably be pursuing and they're saying, well, we're not going to do it, then your issue might be with the council, and that's a wholly separate process then about how you follow that through. I come back to my earlier point, Stephen, which is that if there are 1 or 2 lots in your scheme where this is happening on a regular basis, it's time to have the conversation with the owner or owners of those lots. That probably shouldn't be you as an individual in this case, Stephen. It should be the committee having those discussions, and you should be raising it with the committee in the first instance. Michael?
Yeah, look, it's always important to actually get a planner's advice about this, because you know, a lot of people, planning law and planning schemes can be a little bit complicated, and I would start there. Now, let's assume that the summary is correct and that short-term stay is actually contrary to the development approval. You then have 2 problems. First of all, the cop on the beat, and we're lucky with respect to planning law that we do have cops on the beat in every single shire because it's the local authority. Now, you can't necessarily force them to do their job unless you're prepared to spend a whole heap of money and drag them into court and say you should do your job. I've found success on occasion by basically doing their job for them and then handing over a brief and saying, there it is, pick it up and run with it. That can work. But you've got to be comprehensive, and you should engage a lawyer to help you with that, and a planner. There are some offences under the Planning Act that you can actually prosecute yourself if you choose to. And that's again about having good evidence and making sure you're in a spot to do so. So the answer to the question is no, it's not the only solution. There are other solutions, but they can be quite expensive, unfortunately.
Yeah.
Okay, thank you. And we just had a comment that came in quickly from Steve, just saying that their committee is holiday letting their properties.
Yeah, that's not unusual. And this is the other thing, of course, is that, you know, I'm always hesitant because you have to sort of take things at face value and say, well, Steve, if Steve's entirely right, and this is all contrary to the development approval, and it's contrary to the bylaws and all the rest of it, it's a terrible situation, and I empathise. In that situation, you know, sometimes practically, it's not worth it to fight the weather.
Yeah, you do have to know, Stephen, how far you're prepared to pursue the situation. That's probably the first question you've got to ask yourself.
Okay, Peter had asked, has anybody run the crystal waters argument relating to the scheme's purpose? In that case, it was about pets, but the purpose of the scheme was taken into account, e.g. if the purpose is old folks' home, then a different decision may be possible than if the purpose is a hotel.
So, Peter, thank you, Peter, for tuning in, by the way. You can always attempt that kind of argument, remembering that in Queensland, an adjudicator has to assess the merits of each case. So it's very much case by case. So, and adjudicators are also not bound by each other's precedent either. So you need to keep that in mind. It's always possible to run the argument, but I guess, Peter, what I would say is you're veering then into what I would term to be a much more subjective, value-driven argument than an objective one. That's how that's what I think would be the problem with that. I don't think it's necessarily a bad idea, and there might be an instance where it works. I'll quickly give you an example that I was talking about before I hand over to Michael. The pets issue is incredibly vexed in Queensland, as it is everywhere. But there are instances where a no pet bylaw has been upheld in Queensland as being appropriate and valid. So if it can be held up for those instances, it might be possible to draw an analogy to a short-term letting situation, but you have to be very specific and very objective, Michael.
Yeah, I'd have to disagree, Chris. I think that the practical result of all the cases that we've had so far is that direct prohibition is never going to work. Regulating it out of existence, so effectively putting so much red tape on it that it becomes difficult to do. When you hit that space, you end up breaching the rule in 180 to do with unreasonable or oppressive, unless you can bring in those factors to do with purpose. And that's a really relevant factor in that particular circumstance. So yeah, it's either the simple prohibitions will get you. If you manage to get around those, then the overall prohibition might get you. And if you manage to get around that, then you're going to have a pretty unique situation, I would have thought. So that's not to say don't look at it, but you'd have to be looking at something that's pretty unique. So
very unique. Yeah.
For example, I've dealt with bylaws and landscaping and architectural codes for incredibly heavily regulated eco village on the Queensland coast. You know, turtle hatchery, low lighting requirements, no domestic pets allowed because of threats to wildlife, that sort of stuff. And that's been entirely appropriate for that circumstance, including because of the planning and development approval and all of the conditions, and then some private agreements that were reached for conservation and providing conservation space. So yeah, it's possible, but you've got to be pretty unique.
Yeah, very much so.
Okay, we've had a comment come in from Paul just to let us know how it's working at his scheme, and he's saying our committee is trying to make Airbnb work by putting signage, building bike enclosures, and helping owners understand what we can do. Their pushback is that our costs shouldn't be borne by all owners.
Can I offer a provocative comment at this point for everybody watching? Having a lot or several lots in your scheme listed on a platform like Airbnb can actually benefit your scheme and can actually increase your property values. How so? I hear you ask. Well, remember, Airbnb has a 360-degree feedback. So the person who stays provides feedback, and the person who provides the letting provides feedback. All of that's on a publicly accessible website. So let's just say, for example, in the building in which Michael and I both own lots, and Michael is consistently letting his lot out on Airbnb, and it's getting 5 stars every time. So it's not just about how fantastic Michael is as a host, but then they also start to talk about the common property and the facilities. Gosh, the lawns are amazing. They are so well landscaped. The pool is astonishing. The lifts work brilliantly, are a dream. The on-site gym, amazing. On and on and on it goes. That's free advertising for your building. That's free 5-star advertising for your building, which in turn can actually push up your property values. Spiel over.
It's good to see an alternative view on all of that. I mean, look, and the other thing too is that, you know, the Body Corp Community Management Act is an interesting blend of user pays and collective responsibility. You know, both of those themes feature all the way through the Act. And while there are some sort of philosophical underpinnings to the differences between those two things where they pop up, you know, when I look at this one and I say, well, you know, in essence, why can't we make those people pay for that because they're doing the activity and we're making sure that they do it properly? Well, it cuts both ways. You know, the reason that you're making sure that they're doing it properly is to ensure that bikes aren't left everywhere and you know, signage is there so that people aren't going in the wrong direction and knocking on your door at 3 o'clock in the morning. And you know, that's not just for the benefit of those lot owners, it's for everybody's benefit as well too. So I see that, you know, they're reasonably minor expenditures and at the end of the day, they're there for the benefit of the community as a whole.
Okay. All right. Well, we might, thank you very much for answering those questions. We might have to leave it there because we're coming up, as we knew we would, right to the end of the session, and we haven't covered anywhere near the amount of questions that we thought we would, but we will be getting back to people with the responses, those people that have submitted bits and pieces to us. But we might just finish a little bit earlier on that topic than usual because we had something come up this week that was, I think Michael and Chris both came across it. They've had a conversation about it and I picked it up from Chris, but it's to do with EV charging in buildings and an alert that came out this week. So I might, Chris, I'll let you introduce this at this point if you like.
Yeah, so in Queensland, Queensland Fire and Emergency Services, which is a more or less independent kind of government authority, released I guess you'd almost call it, Michael, a position paper on EV charging, and had some pretty, intense things to say about it, didn't it?
Yeah, I'm actually doing some research at the moment to try and provide some guidance, particularly to body corporate managers about how to deal with this issue, because lovely thing about technology, sooner or later you reach a tipping point, and when that tipping point hits, a lot of activity happens really quickly. So in advance of that, if you've got a good lawyer, a good body corporate manager, they're trying to give you advice in advance of that as to how to cope with it. This QFES statement is really useful from that point of view because it does provide you with some really good guidance that are going to impact things like insurance. You know, the thought processes around location of these things and the increased compliance costs that you're going to have. It's not, you know, it's not intended to pour cold water on the whole thing, which the QFES does every day of the week, but it is about being safe.
Absolutely. And I think, Nikki, we may even find ourselves doing a webinar on EV vehicles in Strata in the not too distant future. It's absolutely coming up in Queensland as a pretty tricky issue to navigate through.
And we are getting lots of questions from other states in Australia on it as well, and we have had requests. So I think that's probably a good idea, Chris, if we tackle that one in the future. All right, that's great, and we'll share the link to that so everybody can have a read of that when we send the recording out later. So you can have a look, and hopefully we'll get some more information on that out to you in the short term, and then keep an eye out for a webinar session coming up. But thank you again for your time today.
Thanks, everyone. Appreciate everyone making
Thanks, everybody.
Thanks for joining us for this educational session. If you gained value from the information, please like this video. You can also engage further with LookUpStrata by subscribing to our YouTube channel or by being kept informed about Strata news via our regular newsletters. Our subscribe link is listed in the description box below.